Of very important comprehensive reform that was decided this morning by the Commission. It concerns data protection and it concerns all of you. Commissioner.
Ladies and gentlemen, we have done it. Today the European Commission adopted a comprehensive reform on the EU's data protection rule. With this reform, the European Union will create a real single digital market, accessible both for companies and for consumers. It will make Europe more competitive in this field, and it will make Europe an international standard setter in terms of modern data protection rules. Now let me first come to the context of this reform. Personal data is in today's world the currency of the digital market, and like any currency, it has to be stable and it has to be trustworthy. Only if consumers trust that their data is well protected will they continue to entrust businesses and authorities with it, buy online, accept new services. So why do Europe's data protection rules need to be reformed? Well, simply because the rules which we do have, and we have rules, we are one of the few continents in the world which have already rules, they date from 1995. Pre-internet times. Today, the internet, cloud computing, mobile devices allow us to access data everywhere at any time. The new technologies have changed our lives. They make it easier to keep contact with our families, with our friends, to upload photos, contacts, to search for the latest news, to share our likes and dislikes on the social networks. So this is a world with breathtaking possibilities, and it should stay so. It should be a world of innovation. But of course, there are also dangers around these new technologies, especially concerning the losing of control over one's personal data. And the citizens are very worried. 72% of European citizens are concerned that their personal data may be misused. They are worried that companies may be passing on their data to other companies without their permission. And this discourages them to feel free to give out their data. This discourages them very often to buy goods and services online. But we also know that many users, especially the young ones, are not aware of the privacy policies when they create a profile on a social network site. Many users are also not aware that their search data could be used by third parties. So this for the worries of the individuals. But there are worries for our companies too. Businesses are worried because they are faced with many varied, sometimes even contradictory data protection requirements due to different national laws, due to different ways the national data authorities apply these laws, and they are also confronted with a real load of notification requirements. So a patchwork of laws, a load of reporting requirements. This leads to legal uncertainty, to legal fragmentation, and it makes it difficult for companies, most of all those innovative startups, most of all our SMEs, to do business in the European single market. This is a real extra cost, a real extra burden on our companies. And this makes that this digital market doesn't really fly as it could fly. So what are we doing in order to solve this problem? Our reform will eliminate the unnecessary administrative burden, as well as the many costs linked to the different reporting requirements currently existing throughout the EU. It will do so with one main text, a regulation which will enhance the opportunities of businesses who want to do business on the whole internal market, and it will assure a high protection to the individuals. And the second piece of legislation, a directive, to ensure a smoother exchange of information between Member States' police and judicial authorities in the fight against serious crime, while protecting at the same time people's fundamental rights to data protection. Now let me first say what this reform will specifically mean to the business world. A single set of European rules on data protection, valid everywhere across the European Union. So one rule for the 27 member states and for the 500 million people. One data protection authority for one company, a one-stop shop, and one authorization for the whole of the European Union. This will reduce administrative burden and will save the businesses around 2.3 billion euros a year. Now we have a special care for our SMEs or for our micro enterprises, those startups which we want to grow and become big companies. It is like a red thread which goes through the whole regulation. Think small first when you regulate. Help the young companies to become big. Help them to do their job and not to be drowned by administrative burdens. Companies will have to deal with one single data protection authority. As I said, they will be exempted from a lot of rules they have to obey to today. They will be burdenless. May I give you some examples on this light touch? First, many, if not the large majority of SMEs, our definition of SMEs is the usual one, by the way, 250 employees, so it has not changed. It is the current one, and it's going to stay the current one. So, the large majority of SMEs will be exempted from the obligation to appoint a data protection officer. Regarding the obligation to carry out data protection impact assessments, the criteria are narrowly targeted to cover only very risky data processing activities. For instance, children's genetic data or biometric data. SMEs will be exempt from the duty to put together documentation on their data processing activities, and this goes through the whole of the law, which means this think small first is not only a declaration, it is in the legal text. The reform will also ensure clear rules for international data transfer inside a multinational company. There will be streamlined approval processes with a single point of contact for companies, and once the binding corporate rules are approved by one data protection authority, it will be recognized by all the data protection authorities on the whole of the European Union. And there should be no need for additional national authorizations in case of further transfers. So far for the business world. Now, what about the 500 million citizens? They also will see immediate benefits, because this reform will increase the trust people must have that their data is well protected, and will ensure that they are well informed about what is being done with their data. And this in turn will greatly benefit the single market, because people will have confidence to use online services, a confidence, as I told you, they don't have, the 72% of people which are worried about what is happening with their data. First rule, on the basis that the personal data belongs to the person. Transparency. Privacy policies must be clear and understandably written in plain language. Citizens will have to know how their data is processed. Second, the consent. To use the data, it will be necessary to give the explicit consent, have been given the explicit consent by the citizen. Citizens will have the right, as they have also in telecoms. Remember, I put this right in place when I was telecom commissioner, of portability, because the data belong to them, so they can take the data from one provider and put it to the other provider. And this data portability will certainly improve the competition among services. And then you all know that about the scandal of the data breaches, where data is stolen, is misused, and citizens hear about this weeks later. We will finish with this scandal. Companies and organizations must notify serious data breaches as soon as possible, which for me means 24 hours, to the national supervisory authority and to the citizen concerned. And then the famous right to be forgotten, again linked to the principle that the personal data belong to the individual. If an individual wants to take off the service the data the individual has put on the service, it should be capable to do so. People will be able to erase the data they have given out if there is no legitimate grounds for retaining it. Now, how will the whole thing work in terms of regulation? I have already told you that there will be a one-stop shop. The national regulator of where the company is seated will be the one-stop shop for a company, and it will also be the one-stop shop for the citizen of this environment. This means that we need everywhere in Europe, for implementing those rules, strong, independent data protection authorities. And when I say independent, I mean independent from politics and from the industry. Well equipped so that they can carry out their task, a task to analyze the case which has been brought before them, a task to give solutions to the case which has been brought before them. And if this doesn't work, the possibility to impose sanctions on the one who has not abided by the rules. This, ladies and gentlemen, is a strong, consistent and future-proof framework for the next decades. It will be applied consistently across all member states and across all EU European policies. It will be fit for the digital age to encourage innovation and development of new technologies and services, and it will make Europe the worldwide standard setter for a digital market and for data protection. So it is really a crucial piece of legislation for growth and for strength. Thank you.
Thank you, Commissioner. I will open this floor up to questions. I want to remind everyone that we have about 15 minutes, but also we have a technical briefing that starts at 1:30. So if there are really purely technical questions, and I know that's a complicated set of legislation, there's a lot in it. If you cannot get the questions answered from Madam Commissioner, they will be answered at the technical briefing. So please hold highly technical questions until later. I will try to get to everyone. If you can keep your questions very short, because we don't have a lot of time. I will start out with Agence France Presse. Christian.
Oui, Christian Spielmann de l'AFP. Madame Reding, je voudrais savoir comment vous conciliez protection des données et justice et police. C'est-à-dire savoir, nous sommes propriétaires des données qui sont dans notre ordinateur. Est-ce que la police peut demander à vérifier ces données qui sont dans un ordinateur? Je voudrais savoir comment est-ce que vous conciliez avec votre régulation la lutte contre le piratage et la fraude. Merci.
For the first question, I said it already several times in this room, there is no right which is absolute. A right is always going as far as it is in conflict with another right. So it is very clear that for the question of the security of a society, of the way the police and the judiciary handle our data, there is the right to privacy of the individual on one side, and there is the right for the society to protect itself against crime on the other side. And these two elements have to be weighted. These two elements have to be combined in such a way that the fundamental right to data protection is not eliminated, but is changed so that it can fit into the security mechanism of a state. That is the reason why I have presented a directive on the collection of data by security personnel, a directive which allows to protect a state, but in the same time does not contradict the basic right to personal data. So that is a directive which cares for this kind of question. The second question, how do we handle copyright and the right to the freedom of information and the freedom of press and so on and so forth? And that is again one of those elements where two rights have to be combined so that they do not eliminate one the other. By the way, my colleagues Michel Barnier and Nelly Cruz are working on the copyright question, and what we have foreseen, data protection is not about copyright. Data protection is about the personal data of the individual, so it is not handled in this piece of legislation. What is not handled in this piece of legislation either, and I know all the journalists in this room are thinking about this, is about the journalistic work. If you journalists make your inquiry, collect data, and write your article, and put this article in your files, in your archives, that is freedom of press, freedom of expression that is not covered by the data protection rules.
All right, we have a question right in front here. Daniel.
Thank you, Commissioner. Daniel Basteiro, Público from Spain. Some data protection authorities and experts are asking for more concerning the right to be forgotten. They say that it is not enough to be able to delete your own data from a social network, for instance, and that the European Union should grant the right to be forgotten, for instance, by telling Google or other search engines not to index content that clearly damages in a disproportionate way the safety or the image of the citizen. Why haven't you included these demands, or are you open to study them? And a second question, very briefly, if I may. Most of the companies social networks, for instance, are based in the United States, and they claim and they say we only want to comply by US rules. So I'd like to know, how are you going to be able to impose sanctions on them? And if I may, why have they been watered down from the original 5% of the global turnover that was being considered? Thank you.
Well, let me start with the last question at once, to tell you that nothing has been watered down. But there have been a lot of discussion, a lot of figures, a lot of declarations, a lot of lobbying. Well, I have at a certain moment stopped to understand what everybody said outside there, because it was so conflicting. So I concentrated on what was in my pipeline and not what was outside there. And what was in my pipeline is now on the table. Nothing else and nothing more. This has not been watered down. On the contrary, it has been reinforced. 5% I have never put up. So, second question. No, first question, actually. Couldn't I have gone further? Now, there are also two opinions out. 3, 4, 5, 10, 100. The ones say it goes too far, and the others say it doesn't go far enough. I'm somewhere in the middle. And what is there in the middle is now on the table of the ministers and of the European Parliament. And our lawmakers have to see if what I put on the table has to stay as it is, if it has to be enhanced, or if it has to be, by them, watered down. Second question. The answer is very simple. These rules are for the whole of the internal market. One rule for the whole of the internal market. Applicable to all people who live in the European Union. Applicable for all companies who want to utilize the golden opportunities of this digital internal market to make business, whatever their nationality be. And to answer precisely the question of the American companies have their subsidiary here in Europe. They are going to be regulated in a one-stop shop by the regulation authority in the state where their subsidiary is, and they will have to apply European law like everybody who is doing business in Europe. Full stop.
Magnus, I think you had a question earlier. Yeah.
Magnus Franklin from MLEX. Could you explain what rules the Commission will be bound by? Could you explain what rules the Commission will be bound by? Does this set of legislation apply to the Commission in the same way as Member States?
That is a separate regulation.
Okay. Let's move on. In the back. Yeah. Sophie?
Oui, Manon Malher, Europolitique. Est-ce que vous pourriez préciser quelles sont les exceptions à l'application du droit à l'oubli? Est-ce qu'il y en a et quelles sont les exceptions? Ou si c'est un droit exclusif? Voilà, merci.
The right to be forgotten is linked to the fact that the personal data belong to the person. So I can do with the personal data, which I freely put on, to give out to a company, I can take it back from this company, give it to another company. I can also take it back and keep it. If the company which utilizes this data has objective, strong reasons in order to need to retain this data, the company has to prove this. So the burden of the proof is on the company and not on the individual. The individual has the right to his personal data.
Good. Okay, right in the back there.
Commissioner Klaus Hecking from the Financial Times, Germany. Horrible, maybe with computer. You mentioned that there were huge lobbying campaigns, and one of the biggest campaigns came from Washington, because at the moment the US authorities still can reclaim access to mass data from EU citizens who are, like, say, customers of Google or of other providers, and they justify this by this Patriot Act, this anti-terrorism law from 2001. Will your new directive stop this or change this? Or will the US authorities still be able to get these data from European EU customers? Thanks.
The Patriot Act is an American law, which, to the reading we have of international law, applies on the American territory. We have introduced, in order to address this issue, recital 90 of the regulation, in order to have the extraterritorial application of the laws, regulation, and other legal instruments which might be in breach of international law, which put a guarantee down for the citizens. So transfers should only be allowed where the conditions of these regulations for a transfer to third countries are met. This is a complicated question. We have put a solution into our regulation, and the future will show if this will be operable or not.
Okay. Stanley, you have a question in the back?
Stanley Pignal from the Financial Times. Vice President, the one-stop shop is a new approach, but I'm seeking to understand one element, which is if a German consumer, say, has a problem with a US social network which is based in Ireland, to use a hypothetical example, would the German consumer have to go to Dublin to make a protest, or would you still be able to lodge a complaint to your local regulator? And very quickly, can I ask, do you have any reaction to the sweeping privacy changes imposed by Google this morning that regroups all their privacy policies into one new privacy policy? Thank you.
Well, Google was quick. Even before the Commission decided on the new European law, Google made the first step in the direction of more privacy rules. I can only applaud all companies to try to move to the right direction. Of course, I cannot now analyze what has been done because I have not yet seen it. I just got the information. But you see, we even don't need to do it. We even need to announce it, and it has already an effect. Now, the first question was about the regulator. Yes. You know that there was the Austrian student who wanted to have his data back from Facebook, being seated in Ireland. And you know how complicated, impossible it nearly was for the student to maneuver with the Irish regulator and so on and so forth. And that was a good example of how it should not be in future. So what will happen to this student in future? In future, this student will go to his Austrian regulator and the Austrian regulator will be in contact with the Irish regulator and ask the Irish regulator to solve the problem. This will be done on basis of the same rules which will be applicable to Austria and to Ireland, and once the problem has been solved, then the Austrian regulator brings this back to the Austrian citizen. One-stop shop for the citizen too.
Ladies and gentlemen, I'm afraid we're running short of time. We have time for one more question, if there's one more question out there. Otherwise, we'll have to leave the space for Commissioner Almunia. In the front.
Zwei Fragen. Zum einen hätte bei dieser Verordnung nicht gereicht, Mindeststandards international, das heißt auf europäischer Ebene durchzusetzen und damit gewisse Grundrechtstraditionen in einzelnen Ländern bestehen zu lassen? Erste Frage. Und zweite Frage, wer kontrolliert eigentlich die nationalen Kontrolleure? Gibt es dort eine Instanz, an die sich ein Bürger wenden kann, wenn die Kontrolleure nach seiner Meinung nicht korrekt geurteilt haben?
Well, that is a typical German question. I have inspired myself with the best, highest standard of data protection rules in Europe. And yes, the German data protection rules are among the best. And that is why, in a certain way, I have expanded the high level of German data protection rules to 26 other member states. Though the Germans should not worry but rejoice, because the standards which were only in Germany now will be everywhere in Europe. And I did not want to have minimum rules. I wanted to have solid rules, rules which will last more than 1 or 2 years, rules which are technological, neutral, strong in the protection of the individual, because you must know, it is not an if or when for protecting the personal data. This is inscribed as a must, as a right in our primary law, in the treaty, in the Charter of Fundamental Rights. So we do have a very high threshold here in Europe of what the legislation must obey to. So very clearly, our rules are strong rules, and they are rules for everybody on a high level, and that is European culture and European tradition. Yes, if now... Yeah, let's take the case now of the Austrian student. The answer he has received now through the collaboration of the Irish and the Austrian data protection authority is not sufficient for him. He's very disappointed. So he has two possibilities. He can directly go to an Austrian court, or he can go to an Austrian consumer protection organization, which for him goes to an Austrian court. So the court is always the last resort. But we hope with this strengthened regulation that even the data protection authorities do not need to put sanctions on the table. That alone the fact that all this is possible will make that the problems can be solved beforehand.
Thank you very much, and technical briefing in a half an hour.